Imagine waiting, hoping for a second chance for your loved one to come home. For thousands of families in California, this isn't just a dream, it's a possibility thanks to California's nonviolent offender parole process. Hi everyone, and welcome back to our channel. Today, we're diving into a topic that's incredibly important for many families across California. The California Department of Corrections and Rehabilitation, or CDCR, and its Nonviolent Offender Parole Review Process, also known as NVPP. If you have a loved one in prison, or if you're just curious about how California is working to reduce its prison population while ensuring public safety, this video is for you. So what exactly is the NVPP? It's a structured process, primarily established under Proposition 57, that allows the CDCR and the Board of Parole Hearings, the BPH, to evaluate and consider the release of eligible individuals convicted of nonviolent offenses. The big goals here are to help reduce the state's prison population, which is actually driven by constitutional mandates for adequate medical and mental health care in prisons, all while keeping public safety as the top priority. The NVPP actually has two main paths. Individuals serving determinate sentences, that's a fixed term, undergo a comprehensive paper review. But for those with indeterminate sentences, often called lifers, it's a more formal parole suitability hearing. This whole process is about looking at an inmate's served time, their behavior while incarcerated, and their commitment to rehabilitation. Now let's get into who's eligible. This is where it can get a little nuanced. A nonviolent offense isn't just what you might think it is commonly. Legally, it's defined as any crime not explicitly listed as a violent felony under Penal Code Section 667.5, subdivision C. So, some crimes that involve physical injury might still be considered nonviolent under this very specific legal definition if they're not in that enumerated list. It's a legal classification, not a subjective one. A key term in determining eligibility is primary offense. This refers to the single crime for which a court imposed the longest term of imprisonment. And here's a crucial point. This definition specifically excludes any enhancements, alternative sentences, or consecutive sentences. To be considered for parole under NVPP, an inmate must have served the full term of this calculated primary offense. For those with determinate sentences, once they've served the full term of their primary offense, they become eligible. But, and this is important, they do not receive a formal parole hearing. Instead, the Board of Parole Hearings conducts a review of their central file and any written statements they've submitted. This decision is made by a deputy commissioner who looks at everything from their criminal history to their institutional records, including participation in rehabilitative programs and any misconduct. Now, for individuals with indeterminate sentences, like life with the possibility of parole, who are not incarcerated for a violent crime, they are also eligible once they've served the full term of their primary offense. For them, the full term is specifically the upper term of the sentencing range for their underlying nonviolent offense. These individuals do get a formal parole suitability hearing, often called a lifer hearing. The main goal of this hearing is to figure out if the inmate poses an unreasonable risk of danger to the public if released. Lifer hearings can feel a bit like mini-trials. You'll typically see a panel of 3 BPH members, the inmate and their legal counsel, and it's worth noting, remaining silent isn't usually seen favorably. The district attorney from the prosecuting county will also be there, usually opposing parole. Victims and their representatives are allowed to attend and speak, thanks to Marcy's Law, and even members of the public can submit information. It's a comprehensive process where the inmate needs to present a strong case for their rehabilitation. It's important to know who is excluded from the nonviolent offender parole review process. Individuals currently serving a term of incarceration for a violent felony as defined in Penal Code Section 667.5, subdivision C, are ineligible. Also, inmates who are required to register as a sexual offender under Penal Code Section 290 are not eligible for this specific parole review process. A Crucial administrative step in the NVPP is the calculation of an inmate's nonviolent parole eligible date, or NPED. This calculation is performed by CDCR case record staff within 60 days of an inmate's admission to prison, at which point their eligibility for parole consideration is also determined. This date is significant as it typically forms the basis for scheduling the inmate's parole consideration. Inmates are formally provided with written notice from the CDCR regarding their eligibility status and their calculated NPED. These eligibility determinations are subject to appeal by the inmate through the department's established inmate appeals process before an inmate can even be referred to the BPH. There's an electronic public safety screening that happens at least 35 days before their NPED. This isn't just about time served. It's about their behavior inside prison. The screening assesses whether the inmate meets specific behavioral criteria designed to evaluate their current risk level. The system checks if they're currently serving a security housing unit, SHU, term and has not been assessed a SHU term within the past 5 years. If they have not been found guilty of certain serious rules violations within the past 5 years, not been placed in a restricted work group C, within the past year, not been found guilty of 2 or more serious rules violations within the past year, not been found guilty of any rules violations involving drugs and has not refused to provide a urine sample within the past year, and has not been found guilty of any rules violations involving a security threat group, i.e., gang-related activity within the past year. Meeting these criteria is key to getting referred for parole consideration. It's a huge incentive for good conduct after the BPH makes a decision, whether it's the paper review or the lifer hearing. The inmate receives a copy of the board's determination. For determinately sentenced individuals, the Deputy Commissioner issues a written decision that includes a clear statement of reasons for the determination. Similarly, in the case of indeterminate sentences, if the BPH panel finds an inmate unsuitable for parole, it is mandated to state its reasons explicitly. This statement must detail any aggravating factors and explain how the inmate's misconduct or other negative indicators suggest a continued danger to public safety. Conversely, if an inmate is found suitable, a release date is established. Concurrently, victims, their family members, and the district attorney's office that prosecuted the inmate, all of whom received prior notice of the inmate's referral, are also formally notified of the board's decision. If parole is granted, individuals released to state parole supervision are subject to specific conditions designed to manage their reintegration into society and mitigate public safety risks. These include general conditions like subjection to warrantless searches of their person, residence, and possessions at any time with or without cause by any parole agent or police officer. Waiver of extradition if found outside the state. Requirement to report to their assigned parole agent within 1 day of release from prison or jail. Obligation to always provide and promptly update their residence and work addresses. And mandatory attendance at counseling and rehabilitation programs. There are also special conditions tailored to the individual's commitment offense and/or criminal history, designed to discourage future criminal behavior and enhance the individual's prospects for successful reintegration into society. Examples include restrictions on internet access or prohibitions on associating with gang members. Refusing to sign and acknowledge the imposed parole conditions carries significant consequences, potentially leading to the board revoking the offer of parole and incarcerating the individual for an additional 6 months. The average duration of parole terms in California is 3 years, though this can extend to 5 or 10 years depending on the nature of the crime for which the individual was incarcerated if parole is denied. All decisions rendered by a BPH hearing panel are initially considered proposed decisions and do not become final until 120 days from the date of the parole hearing. During this 120-day period, the decision undergoes review by the board's legal office. The chief counsel or a designated representative has the authority to affirm the proposed decision, order a new hearing, or modify the decision. If the chief counsel identifies an error of law, an error of fact, or new information that warrants further consideration, They can refer the case for an NBank review, which involves a review and vote by the full board. The governor retains significant authority in the parole process, particularly concerning denials and reversals of grants. The governor can reverse a parole grant, specifically if the incarcerated person was convicted of murder, or refer the decision back to the full board for an NBank review and vote. Understanding the nonviolent offender parole review process can be complex, but it's vital for those whose lives it touches. It's a system designed to balance rehabilitation with public safety, encouraging good behavior through clear criteria, and providing pathways to release for eligible individuals. We hope this video has shed some light on this important process. If you have questions, please consult legal counsel or official CDCR resources. If you found this information helpful, please give this video a thumbs up. Share it with anyone who might benefit, especially families navigating the correctional system. And don't forget to subscribe to our channel and hit the notification bell so you don't miss our future videos on important legal and social topics. Your support helps us create more content like this